Real estate, being an external asset, is always gaining the value. It is the most stable security that human ability has formulated. It is the basis of only an everlasting security. Good morning, ladies and gentlemen. Law Essentials India welcomes you to the 19th edition of the webinar on application of Consumer Protection Act vis-a-vis Real Estate Regulation and Development Act. Law Essentials is a student-run initiative by a group of inquisitive law students having a penumbral idea about the application of life in day-to-day life. I am Mohammed Farhan, founder at Law Essentials, publisher at Law Essentials Journal, and a student at St. Joseph's College of Law, Bengaluru. When technologies change, the human behaviors change, and law has to change accordingly. Since law is meant to maintain order in the society, it becomes imperative for it to evolve and amend itself in order to cater to the needs of changing equation. The Consumer Protection Act 1986 was the legislative response to check the tendencies of the trader community and to protect the interests of the general consumers of the society. The aim of this act is to check the unfair trade practices and deficiency in goods and services. Today we have with us the speakers for this session. Advocate Utkarsha Nikam. She is an associate at Kanga and Co, and she is also an advisor at Law Essentials. We also have with us Advocate Jasleen Kaur, who is an associate at Trialbase Advocate and also an advisor at Law Essentials. Thank you so much for devoting your precious time and conducting this webinar. To both of you, ma'am, we are extremely honored for this opportunity.
Thank you, Farhan, for having me here.
Thank you so much, Farhan. It's a pleasure to be here, and a very good morning to one and all present here. Now, starting with the webinar, I think the first primary question which everyone would be asking, what is the object of RERA? RERA being the Real Estate Regulation and Development Act 2016. Now, to put it in simple word, RERA seeks to provide uniform laws throughout the country, initially for protecting the interest of home buyers, and it also seeks to increase the transparency in functioning of construction of different platforms, for example, plots, buildings, etc. It also reduces the chances of defaulters which keep happening in day-to-day basis, misappropriation of funds by builders. So basically, it secures the interests of the buyers, and buyers which are referred to as the allottees. In RERA, we are very specific to the two terms being allottee and the promoter, because all the transactions that keep happening are very specific to these two particular parties. Now, understanding that, it is very important for us to understand what is the intention of the act. Now, the intention of RERA is also to regulate and promote the real estate sector to ensure that the sale of flats is an efficient and also the transparent manner, this being one of the most important segments. It also protects the interest of the consumers. It establishes an adjudicating mechanism for speedy dispute redressal between the promoters and as well as the allottees. Having understood that, it also establishes appellate tribunal to hear different appeals from the decisions that arise from the RERA authority and also the adjudicating officers. Having understood that, RERA also established in each state for regulation of the real estate sector in that particular state, and it acts as an adjudicating body for the speedy dispute resolution. Now, having understood the importance and the aim and object of the RERA, it is very essential for us to go to the next segment, being the Consumer Protection Act 1986, which is also commonly known as CPA. Now, CPA was enacted to provide speedy redressal mechanisms to consumers. Consumers being a very important term throughout the webinar today, who alleged in a lot of unfair trade practices or there are deficiency with respect to certain goods and services. Now, the question being whether the home buyers are also included within the purview of the act is essential to understand the interpretation of the word services, which ma'am will enlighten us further, which will include or not include. Now, the main question here being definitely being the base, that is are the home buyers allowed to go under the CPA or to RERA authority? We will be discussing that further as we go and proceed with our discussions. But before moving ahead, I feel it is very essential to understand few definitions that we'll be reflecting throughout. The one being of the allottee. Now, what is the term allottee? The term allottee is defined as any person to whom any plot, apartment, or building has been allotted, sold, or otherwise transferred by the promoter. And it also includes a person who subsequently acquires the said allotment either through sale or transfer or any otherwise transaction. But it definitely does not include a person who gives such apartment or building on rent, leave and license, or otherwise. We should understand the main intent that RERA promotes the regulation and sale of transfer of flats between the promoter and the allottee. Having understood that, moving ahead to the another important definition is promoter. Now, as per RERA, a promoter is a person who either constructs or causes to be constructed an independent building or a building which has different apartments or converts an existing building or a part thereof into different apartments for the purpose of selling or some of the apartments to other persons and includes all the assignments. Now, the definition of a promoter is very, very exhaustive and elaborative if you refer to under the section given under RERA, which definitely not includes only new construction, but also includes the conversions which happen. For example, redevelopment, or there are different plots of land, there are different commercial constructions which are happening. It is also inclusive of that particular segments. Now, the Act also covers all the bodies, for example, be it private, be it public, which develop the real estate projects for sale to the general body public. Now, according to Section 2ZK, which defines the term promoter, which includes either both the private parties and the public parties in the real estate promoters. Now, therefore, it's not very restrictive. It includes all types of entities, being an individual or a firm or a company or a trust, state development authority, etc. Now, understanding that, we move ahead to another important definition is that of real estate agents. Coming to the definition, we should understand that for a person to be a real estate agent, he needs to fulfill two conditions. One being the act of negotiation, and second being the receiving remuneration or fees for such services, which services for the act of negotiating, which I referred in the point one. Now, as per the provisions of RERA, if you are a real estate agent, it is very necessary for you to get yourself registered at the real estate agent with the authority. Now, moving ahead, Jasleen, ma'am, would you like to add further?
Thank you so much, Utkarsha, for that introduction to the Act. And as we all know, we are going to be discussing the application of the Real Estate Regulation and Development Act. Especially now we know that before this act, there was no statute in our country which was regulating this sector. Either for the promoters, or I would say the major stakeholder, the developers of this industry, or the purchasers or the consumers of this industry. But after the enforcement of RERA, we have a specific and a special enactment to that effect. And the best part is that all the specific problems of this industry have been dealt under the Act. And as RERA is a special enactment, it definitely deals in much more depth, like I said, towards the problems of the major stakeholders of the industry. Yes, we had the Consumer Protection Act, but it wasn't enough to deal with problems such as say the completion of the project on time, because there was no regulation at that point in time. However, now, as Utkarsha also mentioned, it is important that a project which is ongoing, especially as on the date of commencement of the Act, to get registered with the respective regulatory authorities. For example, if you are in the state of Karnataka, the real estate regulatory authority is in Bangalore. If you're in Maharashtra, the real estate regulatory authority is in Mumbai, and so on and so forth. So it is important that the projects in the entire state are registered with that regulatory authority, and that is the authority which regulates. Now, why we are discussing the definitions of the stakeholders under the Consumer Protection Act and the Real Estate Regulation and Development Act is because we're going to be talking to you about the jurisdiction of these two forums or tribunals that are established under these two enactments, and the jurisdiction deals with the parties who can approach the court or who cannot approach the court. So now Utkarsha has already spoken to you about how the allottees are relevant and how the promoters are relevant. When we come to the Consumer Protection Act, the only person who can approach a consumer forum is the consumer, right? Now, and against any relief or remedy that he wants or for the deficiency in the provision of goods or services. Now, the question that comes into picture is whether the delivery of the apartment to a purchaser is the entire transaction, is it a goods or a service, right? So though technically when we deal under the law, we want to treat that as goods, because that's what gives the right kind of relief and the right kind of approach to the authority in the interpretation of law for the benefit of the allottees. But actually it is not a good, because it is built on a piece of land which is an immovable property. So when we come back to the definition of a product seller under the Consumer Protection Act, it tells us that a product seller also includes a manufacturer who's a product seller or a service provider. Okay, so a manufacturer is who is a product seller or a service provider, but it definitely does not include a seller of immovable property unless such person is engaged in sale of a constructed house or in the construction of homes or flats. So, Farhan, can you hear me?
Yes, ma'am.
Yes. So, but it does not include a seller of immovable property, and that is where the interpretation comes into picture. But the act goes on to say, unless such person is engaged in the sale of a constructed house or in the construction of homes or flats, and therefore a product seller, that when we come back to the real estate industry, we can construe it as the developer or the promoter in this industry. So these are the major stakeholders of the real estate industry. Now, the question on the jurisdiction of these two forums or authorities, before the Real Estate Regulation and Development Act, of course, all the allottees or all the purchasers were seeking relief before the consumer forums or the state commission. But after the coming into force of RERA, under section 31 of the act, any person who has to seek a remedy or relief against a promoter can approach the adjudicating officer. So when it comes to RERA, the dispute resolution mechanism is divided into a threefold manner. The first one is the adjudicating officer who has the right to adjudicate disputes under sections 12, 14, 18, and 19 of the Act, which deal with the basic problems which the allottees face. For example, compensation for deficiency in service. Say 2 car parkings were promised to an allottee under the agreement for sale. However, only one was delivered under the sale deed. So those kind of small problems, or there's a delay of say 1 year, 2 year, or there is an inordinate delay in the delivery of the apartment. So in those cases, the allottee can approach the adjudicating officer. Or there was a promise which was made under the agreement for sale. However, that promise was not fulfilled. Or there certain documents which were supposed to be handed over to the allottees at the time of booking the project or at the time of delivery. For example, the sanction plans or the layout plans or the occupancy certificate, those kind of documents, when they are not given to the allottees. Or when we come back to section 19, it says if the promoter is not registering the apartment on time. So those kind of very uh, basic issues, which are the common problems of the allottees, can be dealt by the adjudicating officer. But when we and then the second mechanism is the authority, which deals with larger interests of the consumers under a project. For example, the formation of an association. So every project which is a condominium, it is important that a promoter forms an association of allottees, and after the occupancy certificate is obtained, the promoter hands over the entire project to the allottees, individually the apartments and collectively the common areas to the association of the allottees. So these are the larger interests. Or if there is some problem with the accounts which are managed by the promoter with respect to the project, so in those cases the authority steps into picture and deals with the larger interest of the consumers in the project. Or the cases where a penalty has to be levied in very extreme cases where there has been more than 10 years of delay and there is no sign of completion in the project, or where there is diversion of funds which was collected by the allottees to say any other project or business of the promoter. In those cases, the authority steps in. And of course, the third one is the appellate tribunal. In any order or direction which is passed by the authority or the adjudicating officer where the parties are aggrieved, can approach the appellate tribunal. And the only people who can approach the real estate regulatory authority is either the allottee, the promoter, or the real estate agent. And in case of the consumer forum, the consumers, yes. And that is why we were dealing with the definition. Yeah, Utkarsha, you want to add anything?
Yes, ma'am. I think you've given so many illustrative examples to understand the actual practical scenarios and how one can go about it. Now, I think we can come to the main theme for the webinar today. That is it even legal to approach the consumer panel after the arrival of the RERA? Now, having said that, let's be clear about one thing, that home buyer has every legal right to approach either the RERA or the consumer panel or both at the same time to seek relief in case when he is having an issues with the developer. Now the issues have been already illustrated by the by ma'am very particularly, and we can obviously understand what are the practical scenarios and how we can go about it. Now, why do I say that it is legal to approach either the consumer forum or RERA or wherever the consumer deems fit? I would like to place reliance on the two judgments. The first one being in the case of M3M India Private Limited. This judgment, what had happened is which was passed by the Delhi High Court. Now, this was a petition which was moved by several real estate companies against an order which was passed by the National Consumer Dispute Redressal Forum, which is commonly known as NCDRC. Now, the question for this particular judgment for consideration was whether the proceedings under the CPA, that is 1986, can be commenced by home buyers against the developers after the commencement of the RERA, that is which happened in 2016. Now, what happened is the NCRDC DRC in its order stated that the remedies which are provided under CPA and RERA are concurrent, and the jurisdiction of the forums or the commissions which are constituted under the Consumer Protection Act is not outstayed by RERA. Now, why do I say this? If we refer to particularly Section 79 of RERA, which provides that no civil court shall have jurisdiction over matters which is empowered to be decided by RERA. And under the Act, and no court shall even grant an injunction in pursuance of any power which is already conferred under this Act being the RERA Act. Now, while passing this judgment, the High Court also placed a reliance on a very recent Supreme Court judgment, that being a Pioneer Urban Land and Infrastructure Limited, which is also very commonly known as flat buyers case, wherein it was held that the remedies which are given to allottees of flats are concurrent, and they are in a position to avail different remedies be it available under the CPA or the IBC, it will also trigger the remedies which are available on the other alternative platforms. Now, it was definitely observed that the provisions of the RERA are not intended to be exclusive, but to run parallel with the other remedies, and the High Court, followed by suit, which was already instigated under the M3M case, which I said earlier. Now, the main point to be taken here is that the remedies to the allottees under various statutes such as RERA, IBC, CPA are concurrent and not they are not debarring the remedies of other laws. So allottees can always approach whichever remedy which they deem fit for the speedy redressal. However, to add to the further arguments that I have been substantiating, I think Jasleen ma'am would be able to clear further doubts if we have in our minds.
Yeah. So thank you, Utkarsha. What was happening is, as soon as the RERA got enforced, the problem which most of the litigants were facing is whether we should approach RERA or whether we should approach the consumer forums. And that is very natural because RERA is a baby legislation. So when people slowly started understanding that yes, RERA is the special authority and that's where we should approach, again, on the point of law, it came to the question of registered and unregistered projects. So Utkarsha spoke to you about the requirement of registration of ongoing projects. I think even I mentioned it. So under section 3 of the Act, what happens is on the date of enforcement of the Act, if you're a developer and your project is an ongoing project, which means as on the date of commencement of the Act, the project has not received the completion certificate or occupancy certificate, as it may be referred in different states across the country, you are liable as it is a statutory requirement, and you're liable to go and register the project with RERA. And that is for easy regulation, which is one of the most, it's in the preamble of the Act. Now, the question which arose was, in case of unregistered projects, does the authority have jurisdiction? Because when I have not registered the project with you as a developer, then I will obviously not come and defend my case or file a case before you, and I will definitely go back to the consumer forum. So this is the question which was being asked, and even as practicing lawyers in the initial, say in 2017 and 18, we were not filing projects regarding unregistered, we were not filing complaints regarding unregistered projects in the Real Estate Regulatory Authority. And even the authorities across the country had not settled that question of law. And when we were going as allottees, or when we were going as real estate agents against the promoters, what was happening is the promoters were taking this defense that as we are not a registered project, we do not fall within the jurisdiction of this authority, and that is why this complaint is liable to be dismissed. That is a problem which was being faced, and the issue with this scenario was that the promoters were finding out ways to exempt their projects from the ambit of RERA, and that was hampering the main object of the Act, which was the regulation of the industry. Now, very thankfully, the Haryana Real Estate Regulatory Authority came back with a judgment, I think last year, where they said that even in case of an unregistered project, the consumers have a right, or the allottees have a right, to approach the Real Estate Regulatory Authority with the interpretation of the law that under the Real Estate Regulation and Development Act, there is no bar for the allottees to approach an authority as against an unregistered project. So when you see the Act, it just says that an ongoing project has to be registered. It does not say that in an unregistered project, the allottees cannot approach the authority, or only in case of registered projects, the authorities can approach, or only a registered project falls within the ambit of the Act. So they interpreted the Act in such a way so as to include the unregistered projects also within the ambit. And then we also had, however, that was that judgment was limited to this point of law. Then we also had a judgment from the Maharashtra Appellate Tribunal, and that went a little further to say that yes, it is important that an unregistered project should also be dealt within the ambit of RERA, because the object of the act has to be fulfilled. But then it put forth a requirement that if you are filing a complaint as against an unregistered project, it is important that you first register that project so that it comes within the ambit of the act, and then ambit of the specific regulatory authority and the act, and then you deal with the problems in that project. Right now, let us also understand the powers of the authority in case of an unregistered project. So, like Utkarsha also mentioned, and I also said that under Section 35 of the Act, the regulatory authority has suo motu powers to take cognizance of an issue which comes within its notice, either through media or through an application or a complaint which is filed by the consumer or any other stakeholder of the industry. The authority has the right to the power. The powers are vested on the authority to take cognizance of the issue, and the authority can direct the promoter right away to register that project before dealing with the problems in that project. So this is how the question was settled, and now the position is that even in case of unregistered projects, you can approach the authority, provided the primary relief in your complaint is that you need registration of the project, or the authority has understood the facts and circumstances of the case, and it is of the opinion that yes, this project needs to be registered. I'll also talk to you about the facts of the case in the Maharashtra Real Estate Appellate Tribunal judgment. So what happened is, in that case, the project was not registered, and the authority also went ahead to find that the project documents, so every land, when it gets converted from an agricultural land to a commercial or a residential land use, the documents have to be clear in order for the promoter to register the project with the authority. So the process of registration under Section 3 is very, very comprehensive, and the kind of details and the information which the promoter needs to upload on the website of the authority are much, much detailed. And they go to the extent of asking the promoter what kinds of litigations are pending with respect to the project land. So when this particular project was not registered and the authority suo motu took cognizance of it, it found that the project documents were not clear, and therefore the authority cannot register that project. Right? So what happens here is, a consumer or an allottee approaches the authority for some kind of a relief, and it says that please register my project because these are the issues that I'm facing. And the authority says, okay, we will register the project, but before that, I'm going to look into the facts and circumstances and see if the project land is completely all right. And when it does that, it finds out that the documents are not clear, and the authority refrains from going ahead with the registration of that project. So effectively, what has happened here is that the authority has not been able to give a relief to the consumers who are adversely affected by the project. And now the only relief which is left for the consumers is to go back to the Consumer Forum or the State Commission or NCDRC, depending on the pecuniary jurisdiction. Yeah. So this is how the law is being interpreted right now. And therefore, though, Utkarsha has mentioned initially that both these, the authority and the Consumer Forum or consumer panel, they have concurrent jurisdiction and they're not in derogation of each other. When we come to the facts and circumstances of each case, there are problems which arise and we're not able to fit those facts into the law. And then the news now is that the allottees have every remedy, and yes, the authority is going to help the allottees and promoters in every issue. But when this came, and the allottees were shocked to find out, because if I tell you the sentiments of the people when they come to us to file a case with RERA, they're very, very emotional, because they would have invested their entire lifetime of this savings into the property and they wouldn't be left with anything in their bank accounts. And then when they come to us, we tell them, hello, your project is not registered and I may not be able to do much with your case. And then, but I'll still go ahead and try and give my best. So when I do that, and then the authority tells us that, we cannot do anything in this because the documents are not clear. I mean, factually, yes, there is the deficiency or the bad lies with the promoter, but the allottees sometimes find them in a place where they are helpless. So I don't know what happened in that case earlier because that's a very recent judgment. But I'm sure the allottees would now they would be forced to go to the consumer panel and to talk about the benefits of the consumer forum, and then we'll come back to RERA. In brief, I'll ask Utkarsha. Yeah.
Thank you so much, ma'am. I think ma'am has left the segment on a very interesting question. Like one can go to RERA also, consumer forum also. So, what are the different issues? And let us try to step back and analyze the which forum or which authority will have an upper hand on different issues. For example, now talking about the issue of applicability, I think it has to be RERA because RERA is constituted very specific to the transactions, as I said earlier, between the promoter and the allottee. So it is a very dedicated court. There is also higher probability of faster hearing because the issues which primarily are dealt with RERA are obviously related between the transaction of promoter and allottee. So it becomes a dedicated court. There is a very higher probability that the cases will be heard sooner. There is a better distribution for claims for any pecuniary limit. Now, if you consider a consumer forum, the pecuniary limit acts as a little hindrance in some cases because the state can entertain, district can entertain, national can entertain, or ranging between disputes of certain amounts. But when it comes to RERA, any person who has a registered project, who is an allottee and promoter under RERA and falls within the ambit of the real estate project can approach the RERA authority. So it makes it easy access wherein there are a lot of problems which are faced by either the promoter or the allottee. Now, one important point is RERA can also take cognizance of any misleading actions or unfair trade practices which are taken or conducted by the promoter in the first place. That means they can act on complaints which can be done on a suo moto notice. They can take cognizance and take the matters in their own hands and to make sure that proper investigation is done, proper remedy is given to the allottees at the end of the day. So they can take suo moto cognizance of all the unfair trade practices or the complaints that are happening in the real estate sector or specific to these transactions. Now, with respect to the ease of filing a case, I think RERA again here has an upper hand over filing a case because now RERA has a very specific format with respect to filing a complaint or a case. But while talking about the Consumer Protection Act, lot of consumers expect similar results under the CPA. That is not the case when we come to RERA. RERA deals with the issues in a very particular manner because that authority is constituted primarily to deal the issues between the promoter and allottee. Since it is so specific to the issues that are dealt with these two parties, the focus of the authority and taking different viewpoints and considering the practical aspects is more referred under RERA as compared to the CPA. When we talk about the success of litigations, now, as strange as it might sound, sometimes or generally what is happening is more or less it's similar between RERA or the CPA. But what happens is the CPA scores a better track on record because due to the good past record of litigation, and since it's not very specific to these two parties, as I mentioned earlier, with respect to the ease of filing a case, they have to give own orders. They can take the penalties that they can impose on their penalties are on a very restrictive manner, and it's like a blanket penalties which are given. So which also enhances the speedy dispute between either the promoter or the allottee. But having said that, when we take all the points into positives, like between two sides, RERA will always have an upper hand because RERA in the first place is constituted to deal with the issues between these two particular parties, whereas consumer can deal with all the issues ranging given that the particular person falls within the definition of the consumer, and the services that are availed are within the definition or the ambit of the CPA Act. Now, as mentioned by Jasleen ma'am as well, now who can file RERA, who can file the CPA? Now, a purchaser, a home buyer, or a prospective home buyer, etc., can file the complaint with respect to RERA. But under CPA, it has to be very specific. It has to satisfy the requirement under Section 2D of CPA. Typically, an individual who enters into an agreement for purchase of flat can definitely file a complaint, and he purchases for either for his individual use or for the residence, for example. Having spoken that, the case timelines, now of course it takes few months to years, either you go to RERA or the consumer forum. But again, RERA being a dedicated authority, there might be a slight chance that since they're dealing with a very specific issues, the process might be expedited. Now, accessibility, when we talk about the main, I think, concern here comes in. Now, when we talk about the RERA offices, there are at least 1 to 2 RERA offices in each state which are constituted under the authority. But when it refers to the forums, there is district, there is state, and there is national. So, usually the allottees have a very easy accessibility to the RERA forums because, as I mentioned earlier, every authority is constituted in every state in order to look into the matters of a particular state given in a particular jurisdiction. So they can deal with the primary issues with respect to the existing practical scenarios which are there already. Now, when we talk about the reliefs that are provided, I think RERA definitely has an upper hand because consumer forum can at most give directions either to refund the money or provide some reliefs. But when we come to RERA authority, it has so many benefits which can deteriorate the parties for not going into such malpractices or not to conduct such practices in future. For example, as you know, the first primary step is that the RERA project should be registered. So you cannot advertise before registering it. So the authority can always revoke the registration ID which is provided under the act. They can always revoke it. They can impose huge penalties on the developer or on the allottees depending who the party is in not acting in the lines for which the act is constituted and who is violating the basic line. For example, if at times what happens is the allottees, even after the promoter is giving the possession, the OC certificate, occupancy certificate, the allottees refuse to make payments, the basic delayed payments which are remaining with, because usually they pay in installments. So they refuse. So under law, once the promoter is giving you the OC certificate, the allottee is bound to make the remaining installments because he cannot refuse it under law. So it usually depends which party is seeking what reliefs, but RERA gives a more blanket coverage because under RERA, if they can grant you a registration, they can also revoke it under certain circumstances. They can also impose huge penalties. They can also give you penalty and also the imprisonment factor which comes in, which RERA forum does not have the authority to entertain too. So, having analyzed different scenarios, different practical views, I personally believe that RERA would have an upper hand over the consumer forum, given the fact that it has so much of variations with respect to dealing each aspect of the uh, uh, complaints that are coming in and the remedies which would be provided or given back in return, either of the parties, either to the allottees or to the promoters. Having said that, I think Jasleen ma'am has a very interesting points to add to it. So for
Okay. What is that interesting point, Utkarsha? Just remind me, please.
For a further talk about with respect to the jurisdiction.
Okay. So, just to before I step into what Utkarsha said that she was also talking about how detrimental the orders from the authority can be. So, just to give you an example, so if the cost of a project, a medium-sized project, say it's about 50 crores, and there is the promoter ends up violating the provisions of the act, say it does not register the project, or after registering it gets into unfair trade practices or diverts the funds of the allottees to another project, which is a very common practice here back in India. So what will happen is the authority, it can levy a penalty under sections 61 to I think 67 or 68 of the act, and the amount of the penalty that is levied, it can range from 1% to 10% of the estimated cost of the entire project. Now, 50 crores is not a very big deal when it comes to a project. They range to thousands and thousands of crores. So you can imagine, even if 1% of the estimated cost of the project is levied as by way of a penalty, how drastically it affects the promoters. So that is the power of the authority, and that is a statutory power that is vested on the authority, which does not lie with the consumer forum or the state commissions. So that is one very big benefit of the Real Estate Regulation and Development Act. And the authority, of course, impliedly, it has inherent powers. And like I said, it can take suo motu cognizance of the complaint. So in case where the promoter comes, say, even if it is not taking the defense of the fact that it is an unregistered project, say it is questioning the locus standi of the complainant, even in those cases, even if the promoter, I'll tell you how the locus standi provision is very, very wide under RERA for the allottees and the association of allottees. But even if the promoter is successful enough to convince the authority that this person does not have the right to approach your kind selves for whatever reliefs, the authority can say that just because we now know what is going on with the entire project, we are in a position under the act, we have the power under the act to deal with that issue, irrespective of the fact that the complainant or the allottee or the association of allottee has the locus standi or not. And that is because the under section 35, they are vested with huge and wide powers. Now coming back to the locus standi of we dealt with what kind of projects and what kind of projects can be dealt by the authority in case of a litigation, etc. But who are the people who can approach, and how RERA has an edge over the person who can file a complaint before the consumer forum and before the RERA. So what happens is, in case of a consumer court, only a purchaser in a project or a registered body of persons or a registered association can approach the consumer forum, which means that either I am a purchaser in a project and I can approach the consumer forum, or if the project say has 100 apartments, me with 99 other people, or say 50 other people in that project, we can form an association for the welfare of the allottees in that project, either under the Societies Registration Act, or we register ourselves as a welfare association, or we under the any relevant law, we register ourselves, and when we are recognized by the state as a separate entity, only then we can approach the consumer forum. And that is the definition of a consumer when it comes to the allottees under the Consumer Protection Act. But when we come to RERA, the definition of a person, so even section 31 and 35 both start with the words that any person can approach the authority in case of blah blah blah. And when we come back to the definition of person under the act, it is very wide, and it does include even unregistered association of persons or body of persons. So even if I now, in the first instance that I spoke to you about, I had to go back to the Societies Registration Act. I had to comply to the provisions of the Act. I had to see, okay, whether I can or cannot form an association of allottees, and then check my locus standi before the Consumer Forum and do all that stuff. So I'm talking about class action suits where the allottees want to go against a promoter to protect the larger interests. In those cases, before the advent of RERA, it was very difficult because they had to first formulate themselves into an association and then register themselves and then go to the Consumer Forum. However, in this case, now here, why I'm speaking about this is because when all the allottees come together, it's very difficult to get connected in a, they don't know each other, they don't trust each other, and when a larger issue crops up, they are not ready to, these are, very ground level facts that I'm speaking to you about. They don't want to come together, they don't, because everybody feels that the other person is biased towards them, and they will probably take up the issues which are more important to them than the larger interest. So those kind of issues come up, and therefore it is difficult to form themselves into an association. But at this point, after the coming into force of RERA, even if those kind of trivial problems, I could say, if they exist in any project amongst the allottees, they can just collectively form a body of persons which is not registered. Okay, so they can just say that we are 10 people and we want to go against the promoter, or we are 20 people, we want to go against the promoter and we don't want to register ourselves. So even in that case, the Real Estate Regulatory Authority entertains their complaint, even if as a body of persons they are not recognized under the state, under any enactment. Okay, and that is how the definition of person who can approach the regulatory authority is very, very broad under the Act. Yes, so I think to that extent, to the extent of the jurisdiction and to the extent of the people who can approach the authority, registration, not registration of project, locus standi, definitions, we are done. If anybody has questions, unless Utkarsha wants to add anything, we can just move ahead with the questions.
I think, yeah, we can proceed towards the question answer segment.
Surely, ma'am. I think we have few questions coming in from the audience. The first question coming in from Prachi. Where does the penalty go? Does the penalty lie with the government or it goes to the buyers?
No, it does not go to the buyers. The penalty definitely goes to the government. And the penalty is because you know that the Real Estate Regulatory Authority is a statutory body, and it has the powers to collect the penalty, and the penalty does go to the government. And then in those cases where the penalties are levied, where we've had cases going a step further that these projects and these developers are also blacklisted. Yeah, and there's a separate circular to that effect.
We have the next question coming in from Sahil Choksi. If the property agreement was signed before the RERA Act commenced, then can the buyer claim interest from the builder?
I just love that question. So this is a very wide, Sahil.
I think just one more add-on to that question. What if an agreement is made under MOFA before the commencement of RERA? I think it's a conclusive question.
Yes. So on the interest, what happens is, like even like personally, I have been trying to argue that point on the based on the logic that if the allottee has to seek interest based on the agreement, then the allottee also has to rely on the end date as per the agreement, which was entered into before the coming into force of the Act. However, if the allottee is relying on the Act for the purpose of claiming interest from the promoter, then the allottee has to go back to the end date which is provided in the registration certificate of the by the respective authority. But till now, we've not had a successful judgment on that point of law. And what the authorities are doing, at least in Karnataka and even in Telangana, Gujarat, yeah, those are the kind of orders which I've seen, where they consider the end date as a from the agreement, even if it was entered before RERA, on the ground that the promoter has gone ahead and registered the project because it was not it was not completed on as on the date of the enforcement of the act, and then they levy the interest as per uh, the act. So that is what they're doing. So there is no, in my view, it is wrong. And in my view, the if the end date is from the agreement, then the interest also has to be from the agreement, whatever it is, 3 per square feet or 4 per square feet. And if the end date is from the registration certificate, then the interest also be it has to be from the act. But yes, we've also had views where they say that RERA, for the purpose of interpretation, it has two parts. One deals with the compliance, and one deals with the litigations under RERA, and those two cannot be interpreted together. And that is where the end date and the interest part clash, and that is where the conflict arises. But we've not had any judgment, though we're trying to argue that here. So yeah, yes.
I think we
There
have the
was,
next question from Anu Sharma. I think you want to complete, ma'am.
yeah, I think Utkarsha can answer that question.
Yes, absolutely. So when we talk about the rights and duties of a buyer, they are as compared to the promoters, the rights and duties of a buyer and are very lesser instance, I would say, because promoters' duties start from the day when they receive the login and password ID once the registration is done till the time they convey the property or the flat to the particular allottee. And even after the conveyance, what RERA Act has done is that they have imposed certain duties or the duties obligations on the promoters, wherein even after the conveyance, if there's any structural default, etc., the promoter can be held responsible. But when we talk about the duties and the rights of buyer, one major right would be he or she, the buyer has to make timely payments, because as I mentioned, this there was this one case, Pioneer Association, in which when the builder, the promoter was giving an OC, that is the occupancy certificate, that the flat is ready for possession, the allottees were refusing to make the balance installment on the basis that the common amenities, for example, which we call as the staircases of flats, they were not completed. Now, one point here we need before coming at, or taking into consideration the conclusion of the judgment is the promoter argued that the project, real estate projects, can be huge. So they were really huge projects, complying of lot of buildings and lot of apartments. So hence the common amenities to be constructed had to take time. But the OC had been received with certain some of the flats, whereas the promoter had given an assurance that by the end of this time, the common amenities will be completed in the due process of time. But till then, the allottee has to make the balance installment, and they cannot refuse. So even the authority agreed to the views of the promoters that once the project is such a huge, based on the assurance given by the promoter that the common amenities will be completed in the due course of time, and once the promoter is issuing the OC, that is the occupancy certificate, the allottee cannot refuse to make the balanced installment payments on the basis that common amenities are not completed. In what instance can a buyer refuse to make the timely payments is, for example, if the promoter has agreed to certain amenities or certain benefits under the agreement, and they are refusing to give during the point of when the OC is provided, or they do not fulfill the obligations, at that point of time, the allottee can refuse to make the delayed payments, like to make the balance payment, and they can take in the interest or whatever is to be charged and take the installments which have they made the payment, they can take it back. So there are very specific instances, but I think the major right and duty would be to make the payments. I think ma'am could add certain other benefits if there's there.
Um, as far as the rights are concerned, I think we're all very clear. When it comes to the duties, yes, one definitely the most important duty which is cast on the buyer is to make timely payments towards the same consideration of the project, of the apartment in the project. And in case where the buyer fails to do that, we have had cases where the promoter has gone ahead and filed a complaint before the adjudicating officer, and heavy interests have been levied even on the buyer. And to that effect, RERA is very balanced. So if say 10% interest or based on whatever calculation is prescribed under the act is levied on the uh, promoter in case of any violation, that same is the rate of interest which would be levied on the buyer in case of violation or a breach of agreement by the buyer. And yes, another very important, I think, Utkarsha, did you cover it? That they have to go and take possession of the apartment within 2 months from the date of occupancy certificate. Yeah.
No, I
So
didn't.
once
Yeah.
occupancy certificate is obtained, and I, as the promoter, I send an offer to take the possession of the apartment to the buyer. It is very, very essential that the buyer comes forward and takes the possession within 60 days. Otherwise, in future litigations, that becomes a very, very strong ground of defense for the promoters. Yeah. And there may be many more, but these are the two most important duties which are, yeah, as far as the buyers are concerned. Yes.
I think we can have many questions related to RERA, but this question was very striking to me as a law student. How to remember sections of any act? Maybe you can tell it in particular with RERA.
Okay, so when you practice, the only way you can remember the sections of any act is not by reading the bare act. You have to go and practice under the act. You have to read it regularly. It has to be there in your mind. You have to deal with problems under that act. As a student, writing articles on the provisions of law and reading judgments on the provisions of law, speaking to your seniors, and probably some lawyers with whom you are connected who are well versed with any enactment that you want to remember the sections of. You can be in touch with them, and yes, I think writing articles and reading judgments and understanding the application of the judgment than just reading it. So why is it that principally the judgment spoke about something? So for example, yes, so like as of now we're dealing with RERA. So if I say that a promoter has to register the project under section 3, but why is it that the promoter has to register it? So that the authority can take cognizance of the project. But why? So that it can regulate the project or the industry well. But why? So that the consumers are more protected. Why? Because they've served, they've paid a lot of money. So I think you need to keep on asking that why, and you need to go deeper into the sections, and that is how you need to work on it more, either by way of practice or by way of writing articles or getting into rounds of discussions with your friends. Yeah.
I think
We have one
I
question.
think ma'am has, sorry to intrude, but just ma'am has given excellent pointers with respect to the practical, aspects. But I think one thing is any act you refer to, you see the body, the base structure. It just is in a very flow. For example, starting with the aim and object, then you have the definitions. Then there's this flow that what is the primary part being the registration, the all the process with respect to registration. Then you have what happens, what are the duties caused due to the registration. Then we have what are the penalties that can be imposed if you do not follow that particular rights and duties. Then you have the provisions with respect to when you do not follow, then what are the ahead jurisdiction comes in. Then if you have jurisdiction, of course there will be penalties which will be levied. So there is always a flow. So trying to understand, which ma'am said, why it is happening, and as you proceed further to further sections, it will be answering the questions to your why, like what would happen further. So just try to understand the particular section and then move ahead, I think. Farhan, you can please proceed.
Surely, ma'am. The next question is: can you recommend any detailed reference book on RERA?
I think
Utkarsha,
ma'am
because
would be.
I have not. There are. I think they're yet to come out. Yes, there are, but even I am not sure about a very good publication till date because the law is still developing. But I think I can just check back because I have a few commentaries in the office. I can check what is the publication. I can get back to Farhan and probably you can take the details from him. But anything like, we have Avtar Singh and all of that, nothing so comprehensive on RERA. Utkarsha?
I totally agree with you, ma'am. But the one book that I had referred initially is it was with respect to only RERA. But I think RERA being a developing act on everyday basis, the judicial stance changes every day. So there's nothing concrete that you can take it as a Bible. You have to always keep yourself updated with respect to all the circulars or notifications or the RERA judgments that are coming into place. And that is exactly what you can take ahead as a Bible and then proceed further. So I think it's
Yes.
being a developing law, there is nothing concrete. Even I haven't come across.
Moving further, I think no RERA webinar will be complete without taking something on the field. So I would like to take a few questions from that. After making the payment of balance due amount, what are the options left with the buyer if the builder breaches his promise of completion of the common use areas?
Should I go, ma'am?
Yeah, go ahead.
So, having said that, the case that I was referring to, you can always approach the RERA authority because that being the primary authority of reference, because the I'm assuming OC is obtained and the builder is giving assurance that the common use areas would be completed in due course of time. If he doesn't, then you can always approach the RERA authority, and the RERA authority will impose certain penalties or certain, huge penalties. I'm not even talking about the basic penalties. RERA authority will obviously impose very huge penalties, which will like set as an example for other buyers not to contravene the provisions which are already laid down in the agreement, because whenever you sign an agreement, all the common use areas that would be completed are always mentioned therein. So in a way, it's an contravention of the obligations on the part of the promoters, and it is one of the duties of the promoters to comply with the agreement that is in place and to deliver all that is promised under the agreement for sale with respect to the allotee. So I think RERA would be the appropriate authority when a speedy remedy can be availed of, and huge penalties will be imposed until the day the common areas are completed. So I think this would be it.
Yeah, just to add to that, when you go to the definitions of the act, you will find the definition of common areas specifically. You'll also find the definition of internal development works and external development works. Now, I am also assuming that the occupancy certificate is obtained in this project. If it is not obtained, then definitely you can approach the authority under Section 35, and you can say that the internal development works in the common areas are not completed in this project, and having paid the 100% of the sale consideration, I'm entitled to so, depending on what is your intention of approaching the authority. If you are only looking for a compensation, because when I say project completion, I just don't mean that my kitchen and my bedroom and my living room is complete. Because I'm moving into a project, I'm paying a higher cost. I also want the swimming pool, I also want the tennis court, I also want the gym, and every other, even it's a walkway or even it's a simple lamp, okay, which was promised to me. In fact, I'll just go a step further quickly. I know we're losing time, but if in a brochure there is a car which is parked in front of the apartment project and there is a coconut tree, and if you don't give the allottees that car and that coconut tree, you're liable to be penalized under RERA, right? So it is very, very important, and that way Section 12 I think is very important, and it has been having detrimental effects on the promoters. If everything what is promised and shown by way of the brochure is not given to you, be it anywhere in any inch of the project, you're liable to get some relief. Now, if you're intending only to get a compensation, you can go and approach the adjudicating officer under Section 12 of the Act. However, if you're looking for more detrimental reliefs like a penalty and the completion or speedy completion or anything, any other creative relief that you can think of in right interpretation of the law, you can approach under 35, you can approach the authority. And you should definitely read the definition of common areas, development works, external and internal.
I think I would like to take the last questions for this very pleasant Sunday morning. If the car parking is allotted far away and not underneath the basement where the flat is situated, how can the property buyer urge the builder to allot the parking underneath the basement where the flat is?
Okay, I'm just reading the question again because I just missed it. 1 second. If the car parking is allotted far away and not underneath the basement where the flat is situated, how can property buyer urge the... Okay, Utkarsha, do you want to answer that?
I'm not sure if I correctly understand, but when you talk about the car parking allotments, and if I'm understanding it correct, when you go to the RERA site and put in the details of the particular project that you're referring in, the car parking allotment will be uploaded. The plan, which is already fixed by the developer with the consent of the allottees, will be already uploaded, and that particular allotment has to be in accordance with the plan that is uploaded on the RERA website. And if I am correct, whatever changes, if it has to be done, it has to be done with the consent of, I think, 10% of the majority of the allottees. If at all any changes in the plan has to be made, so whatever the plan is showcasing, and if the allottee is signing the particular agreement with understanding the particular allotment of that specific caste, uh, he or she, the promoter, would be liable to give what he or she has agreed to in the first place. So, and whenever registration happens, all the plans are already uploaded with respect to the OC, with respect to the architectural plans, with respect to the car parking plans. So it is, I think, the primary obligation of the promoter in order to upload all the documents related to the project, which will happen in future, or which whatever the chain of title documents have already been subsisting.
Yes. Just to add to that very quickly, I think I'll be summarizing what Utkarsha said. It is very crucial that what is promised to you is given to you as under Section 12. If you have checked out the sanction plan and the brochure and all kinds of plans that they are showing you while you're booking the apartment, and the car parking is in the basement and not somewhere far away, it is important and it is mandatory that that is the very car parking that is given to you, else you can seek a compensation or a refund under Section 18, the kind of relief you want to. If there has been a modification, then yes, 2/3 consent of the allottees of the project have to be taken, and a modified sanction plan has to be obtained from the planning authority. And if that has not been done, you can approach the authority, and again, under Section 14 read with 35, you can ask for heavy penalties. I'm not sure if once the car parking is given, like practically somewhere far away, how can you again, I don't know, bring it back. I'm not sure about the practical this thing, but yes, you will be entitled to reliefs, and just check out if there is a modified plan sanction.
I think with this we can come to the end of the session. I really would like to express my heartfelt gratitude to both Jasleen ma'am and Utkarsha ma'am. It was really an enlightening session. The audience has really loved you throughout the session. Thank you so much, ma'am.
Thank you so much, Farhan. Thank you, Jasleen ma'am. It was a pleasure to host the webinar with you.
Thank you, Utkarsha. And I think the questions were really good, and we did have a good time answering the questions. Thank you so much, Farhan and Law Essentials.
Thank you so much to
Farhan
all
and
the
Law
audience.
Essentials.
Thank you so much to all the audience for attending this session.